Do I want to see Harry Waite go to prison? Absolutely not. But I also thought, if they did dismiss with prejudice, we're looking at probably a 4 or 5 year battle. If Harry would be spending more money to go after them in a civil suit. So I didn't expect a whole lot, but I didn't expect it to be as bad as it was.
I,
Meaning
yep.
the restrictions, what he can and cannot talk about, they can and cannot bring up. And it's hard because I'm stuck on the charge of identity theft, and I'm stuck on the fact that in order for it to be identity theft, you have to have gained something of value. And Harry's being charged with identity theft, not disorderly conduct or other things that they talked about. It's identity theft, and they won't let him talk about motive or intent. And without motive or intent, how do you explain why he did this? He didn't do it for $10. He didn't do it to buy a ballot. So it's that part's frustrating.
Mm-hmm.
I didn't think it would get that bad, and I'm just hoping that his team of attorneys will pull a rabbit out of the hat and
Do a
make
magic
something happen
I
between
agree,
now and then.
and Corey, I'm gonna play a clip in a little while that from the proceedings this afternoon that explain motive versus intent, or will allow our listeners who weren't there to hear that exchange between uh, both Harry's defense attorneys and the folks from the DOJ, along with the judge himself, and how he chimed in on that. But I agree. I think it's very alarming because how do you defend what he did if
to
you
prove
if you
to
can't
prove your own case.
if you can't bring motive to
And
the table?
we do have a comment on Rumble from Feisty Gma, which we now know who that is. The judge neutered the case, and that's how I feel. I think she's right.
Right, I really did. I clearly wasn't happy with the outcome today, and I think folks, as you listen to the other one's a little bit longer. The other clip I have is a little bit longer. Quite the exchange, and it'll shed a little more light on kind of the atmosphere in the courtroom today, I think.
Um,
But so Corey,
yeah.
Corey, you were there, and I get what you're saying. If it had been dismissed, and we all know that Harry wanted this to go through because Harry wanted to have his day in court, to so the world would understand what happened. And now I'm not sure that they're going to be able to hear everything that happened, that based on what we heard today. And I'm clearly not a lawyer, but so I understand what you're saying, but I think there were some of us, because we love Harry so much, that there's always the concern that are they going to stoop to levels that
Well,
where
speaking on like evidence, you know, if you have your evidence, obviously you have to share it with the um, prosecution and vice versa. But if you have evidence and the judge won't allow that evidence to be heard, seen, whatever, then what kind of defense can you build
in
and
and
protect yourself?
well, and the jury has to hear the motive, the
Yeah.
why did Harry do what he did.
And I even brought up to some people about whistleblower. How do you prove, or how can you be a whistleblower and show what's going on? Because we all know that hearing it, because I've proved it by saying it to some people that don't believe it. Um, how can you show people if you can't talk about it and be that whistleblower? You know, I don't know what kind of I just how do you show that you're trying to be a whistleblower? But there
Corey,
goes with
Corey B has her
intent.
hand raised again, so go ahead, Corey.
Yes, thank you.
I may have forgot what I was going to say, but I will say that the very first time I met Harry Waite was back in 2022, August of 22, and it was shortly after he was able to find this flaw in my vote, this hole, this you know loophole that was allowing this to happen. And when I met him, the very first thing he said to me was, I need to get it on record. He went to the sheriff and said, arrest me. Here's what I did. You need to arrest me. And because the sheriff didn't look at him as, doing anything of criminal intent at all, he thought, well, he's a whistleblower. I mean, to use a word that Jenny was just saying, that's the way I understood it. That's how the sheriff treated it. Didn't recommend any charges. So um, I know from the beginning, and I'm blessed to have known Harry since then. Anyway, um, that's been his intention, is to get it on the record, and to know now after what we witnessed today, so much of what we know will never be on the record. So we are lucky to have a place like the Ripon Rabbit Hole and Screech Owl Scott and Red Owl and AJ and the Hot Telegram and the videos that they put together. These are the only ways we can tell his story, because you won't find anybody on national news. I don't care if they're on the right or the left. They are not going to tell this story. Where were they today? Where's the Steve Bannons in the world, and the Joe Von Hutton Pulitzer and the Benny Johnsons? I mean, where are they? They don't care about election and integrity any more than the left does. And I'm infuriated by it, if you can't tell. So
Oh, I
And
agree.
we have to stop allowing this. We have to start calling it for what it is on both sides. In the news, on our side, they're not going to report it.
thank
Exactly.
you for pointing that out,
Definitely.
Corey,
Thank you,
because
Corey.
it's not being told.
No,
This
it's not.
story is not being told, and there, to his credit, there was somebody from mainstream media. I don't know what network it was, but Channel 4 out of Milwaukee, I guess, and he was there, and I did not see how they reported this.
No.
Uh,
Maybe we'll catch it on 10 o'clock
But-
news or something, but
but he was the only one there, and the people
Right.
that can get this story out, and all of us at Ripon Common Sense Radio, and like Corey said, in the Gulf or the Hot Telegram channel, folks are going to get this out as much as we can, but there are people with huge reaches who could help get this out, and they're failing. They're failing us big time. Catherine B., you have your hand raised. Go ahead, Catherine B.
Sorry, I'm on my phone, so this is harder than normal. So I posted in the chat that maybe Harry can prove in this climate of election fraud that the ballot is worthless. Use Voss's own words that there is election fraud.
and I can't remember,
So
were they able to bring up my vote at all? I can't remember what they decided on that.
I don't know if they did. I don't think they did decide, did they?
Okay, I don't recall.
I'm not sure that they decided definitively what would be allowed in, but
But I will say that I ordered my ballot. Granted, it was my ballot, and I sent it to my home. But the point is the ID part. I did not have to upload my ID because I checked the indefinitely confined box. Therefore, nothing has been fixed. Nothing. I
So you're
will
gonna
say about within the last month, I did notice when I checked last week, they put up a disclaimer now that check this box under penalty of perjury that you're not ordering somebody else's ballot. But this happened back in 2022, and they just now put it up within the last month.
But they didn't put any any safeguards to
No,
prevent
because I
people
can
from doing it.
still order my ballot without an ID.
And Catherine's got her hand up again. We're going to let Catherine
Sorry,
take
Catherine.
the floor again, because I'm hearing jets coming over our house again, Red. Go ahead, Catherine B.
I missed what you said, but one of the things I was thinking about today that I may try to do if I don't forget about it is I may do a records request from WEC about, or I'm not sure, actually, Harry would have to help with this. I'm not sure who I should do the records request for, but I want to find out what happened to any investigation on that ballot that went to Serbia. I think that
Not
could be a
Serbia.
key.
Not Serbia.
Huh?
Not,
I think it was the Czech Republic.
Yep, Czech Republic. Republic.
Oh, okay. Yeah, sorry.
And
Anyway,
did I tell you about the person that was a delegate at the RNC convention in Milwaukee? Happened to be a
no.
former ambassador to the Czech Republic. Is it a coincidence? I don't know.
Well, when Harry and Jim and a bunch of us were doing deep dives on that back then, we found out that ABC Supply had an office. I think it was in the same building. Yep, somebody just posted that. Yep.
And I'm not sure what ABC Supply is, so you'll have to.
That's Diane Hendricks,
Oh,
big
okay.
donor.
Wow.
Well,
Coincidence?
Yeah, wonder.
That's where
so
the tin hat comes
Catherine,
in.
what was your take on today's hearing? And I'm going to play a break when we're in a minute here. We're going to be taking a break, and I'm going to play another clip from the hearing today. But what was your overall take of the hearing this afternoon, or this?
Well, I think the judge is pretty much giving the prosecution a pass on everything. And I think I guess what drives me crazy about something like this is isn't the defense allowed to bring in anything that can clear them of the charges? Why are they able to limit that? I mean, if you were on trial for murder, I don't think they could get away with that. Well, except if it's hearsay or, something like that. But they can still bring it up at the trial and then just have somebody say, no, you can't say that or whatever. So why is he allowed to stop the stuff before it even gets to that point?
And that's what I was talking about on the way home. You're tying the defense's hands. How are you supposed to? I mean, I know the burden of proof is on the prosecution, but at the same time, you still want to have your defense to prove yourself innocent.
Well, and if the burden of proof is on the prosecution, why are they giving him so many passes to do whatever they want with it?
Right, and to tie the hands of Harry's defense team.
Yeah. So how are you
Exactly.
supposed to defend yourself?
I mean, I felt an awful lot like Harry was being railroaded.
Oh, yeah.
Like they were prepared the minute he said, I reject your plea offer. It was like, okay, let's railroad Harry. I mean, that's how I felt.
And I felt like
Yeah.
it was at one point guilty, and you haven't even gotten to trial yet.
So we're going to see how this plays out in the court of law before 12 jurors.
Yes.
Or 13 jurors, I believe.
Yeah, because they're going to have the one alternate.
But we're going to be taking a break here, folks. And then when we come back, I do want to play a clip, and it's a rather lengthy clip, like about 8 or 9 minutes long, but it'll give everybody in the backstage an opportunity to hear firsthand the things that were being said. So let's just jump into our break right now, Red.
Sounds good to me.
I think. Well, Red, that wraps up the first half of tonight's show.
And I really hope that people stick around for the second half of the show for this very, very important topic.
And it really is. And we'll continue that conversation on the backside of our halftime break.
Halftime.
Halftime break. Folks, this Friday on the Ripon Rabbit Hole Live, just days before the historic March 20th, 1854 meeting at Ripon's Little White Schoolhouse, Wisconsin was rocked by a shocking confrontation that brought the evil of slavery straight into the heart of the so-called Free State. An escaped slave named Joshua Glover was captured. A federal law demanded his return to bondage, and the people of Wisconsin had to decide, would they comply or would they resist? This Friday, AJ the Ripon Rabbit uncovers the powerful connection between the Joshua Glover rescue and the anti-slavery fire that led to the famous meeting in Ripon, Wisconsin. Before there was a movement, there was a man. Before there was a party, there was a crisis of conscience. Before the Little White Schoolhouse became historic, freedom itself was being tested. Don't miss this powerful episode as we explore the human story, the political tension, and the moral courage that helped shape one of the most important moments in American history. Friday night at 8 p.m. Central, Ripon Rabbit Hole Live. And folks, join us live on March 20th as the world connects to Ripon, Wisconsin, for the worldwide Freedom Flame celebration. Through the virtual Little White Schoolhouse, this becomes more than a broadcast. It becomes a live, interactive event that connects the worldwide audience directly to the physical celebration on the ground in Ripon. Interact in real time with people around the world and participants in Ripon as the all-day events unfold live. From sunrise gatherings to the lighting of the Freedom Flame and the candlelight walk of flame. This is your chance to do more than watch history. This is your chance to be a part of it. Visit thefreedomflame.com and add your spark. And Red, you and I, we've already added our spark.
Yes, we have.
And that's our challenge
And-
to everybody listening.
And we may have a special spark added hopefully that day on March 20th.
Wouldn't that be exciting?
We haven't gotten confirmation yet, but it would be extremely exciting in my opinion.
And we'll keep watching that one. So that's our first challenge at this mid-show break, is to go to thefreedomflame.com and add your spark.
And the other important thing, if you care about your freedoms, and in my opinion, this Freedom Flame is just the start of our freedoms. We need to keep it burning as brightly as possible. And we'll carry that over into March 23rd and 24th. Be in Racine on those days for Harry's trial. And, you know, I feel like our freedoms are being slowly slipping away here. And if you care about your freedoms, you need to be there. No question.
We do. And going back to what's happening on AJ Show, you know, one of the things that we said was, would they comply or would they resist? And
I think
this
it's
is our
time
time to resist a little bit. And I don't know what kind of an impact a full courthouse can have of Harry's army, but we have to find a way. And as we listen to what happened today and we continue that conversation in the second half, our freedoms are under attack.
Yeah, and it, like I said, and I cannot stress it enough. If you care about your freedoms, be there the 20th to light that freedom flame, and we need to carry that flame over into Monday and Tuesday, the 23rd and 24th, because if the outcome of this trial isn't what we are even further
to Harry's trial on Monday and Tuesday in Flame out in front of the Racine County Courthouse.
That's a great idea.
I think that would be a good idea for us to gather out there in solidarity and support of Harry, and let's show the world that we're not ready to give up
our
freedoms. And so that's our challenge, folks. Right now, folks, put 100 in the chat if you are going to be either participating live or virtually for the Freedom Flame
on the 20th, March 20th,
and then throw another 100 in there if you're going to support Harry Waite and be part of Harry's army in Racine on
March 23rd and 24th in Racine, and we will put up the address to the courthouse
in the chat.
Yes, well,
all right.
We'll put it up on the screen too.
All right,
for
so
those.
Let's return to the second half of the show. Red.
Sounds good.
All right, and Red, we will get that address out there for Harry's trial.
Yes.
Folks, I am going to play a clip, and we were traveling a good part of the afternoon on our way home, so, you know, our prep time in terms of editing any of this footage that we have, I really didn't have the ability, and the jets are still flying overhead, Red. I don't know what the hell's going on.
Well, Keeter says, turn down the TV. He thinks that we're watching Top Gun.
No,
but we're
not. But in any event, as you listen to this clip, and again, this is an 8 or 9 minute clip, and it's the exchange where they're talking about motive versus intent. And you will hear from all these people. You will hear from Harry's defense attorney. You will hear from the prosecution, from the Department of Justice, and you will hear the judge's input in this. And I think when we're done playing this, I want to get people's feedback on it. But if you're not pissed off when you hear this,
Yeah.
then something's wrong, and you're okay with
Your
with
freedom
what's happening.
being taken away.
Uh,
I will say real quick, the Racine County, or the courthouse, sorry, is at 717 Wisconsin Avenue in Racine, and I will repeat that at the end of the show as well.
717 Wisconsin Avenue, Racine, Wisconsin, and court starts at 8:30 a.m. and will
Both
run
days.
until 5 p.m.
Correct.
Each of those 2 days, and then I'm guessing it will go to the jury at some point on the second day. And our intent, Red, and I'd like everybody to hang around, is to wait for the jury to come back with their verdict on this one.
And I will say we had quite a few hundreds coming through, and I will bring the lamp from Rip and Rob. And, well, obviously, Harry's got to be there. So he put 100, 100, 100. So thank you, Harry. But yes, hundreds across the board. And I see a lot of the hundreds coming in on YouTube as well.
And before I play this clip, I will echo what Corey said in the first half of the show, when Corey said that.
Hold that thought 1 second. It's at the Law Enforcement Center in Racine. Okay, keep going.
I will echo what Corey said in the first half. Some of the big boys in this world who have an ability to reach a lot of people are failing us. So if you're watching those folks that Corey mentioned, get on them a little bit. Tell them to start covering this story, because this impacts everybody. This isn't just a Wisconsin issue, because
No,
what we're seeing in Wisconsin is happening in other parts of the country.
Think Tina Peters.
And this is a whistleblower.
Yep.
And I'll be damned if I'm going to stand still and watch my good friend Harry Waite end up like Tina Peters did.
Exactly.
I mean, it's time to raise some hell, and with our judicial system, if this is the way it's going to be.
Yeah.
And somebody put in the chat, does anybody know anything about this judge? And you know what? We got a lot of researchers in the group. You know what? Start digging. Start digging on this judge. Let's.
You know, and never mind. I lost my thought.
All right. So let me just play the clip, because I know there are a lot of people in the backstage, Red, and people listening on Rumble and hopefully on YouTube, who didn't have the opportunity that we did. And again, I'm sorry I wasn't able to edit this down. So let's just listen to the exchange that should start right about now.
Maybe.
Or now.
Maybe not.
Here we go.
Maybe.
Yes, Your Honor.
There we go.
Your Honor, this case is not about the 2020 presidential election. Allegations challenging its integrity are unfounded and irrelevant to the elements of the charged offenses. Now, if the court wants to let Mr. Wade explain why he committed the offense, if he chooses to take the stand, why he chose to commit fraud, why he chose to use people's personal identifying information without their consent, that's fine. But his personal motivations for committing crime does not give him a legal privilege to assert some sort of affirmative defense. There is a case that's directly on point. I do have a courtesy copy for Your Honor. And that is State v. Olson III, 99 Wis 2D 572. And Your Honor, in that case, and actually coincidentally, this case arose from events that happened about 8 miles north of where I lived, in Genoa, Wisconsin. It involved Dairyland Power Plant in Vernon County. And approach, yes. Right along the Great Mississippi River. Dairyland Power used to operate a nuclear power plant, which was controversial due to the alleged environmental impacts. Mr. Olson and a group he belonged to that advocated for environmental rights had some concerns with the way Dairyland Power was deactivating its nuclear capabilities, disposing of waste, transporting expended rods. And the group, to include Mr. Olson, chose to go to Dairyland Power and impede the process of transporting these rods. And in doing so, committed disorderly conduct. Wouldn't move out of the way when sheriffs asked him to move out of the way. And he was charged with disorderly conduct. And at trial, Mr. Olson attempted to assert been asked to introduce experts, elicit testimony, and provide evidence through other witnesses about the environmental impacts of the generation and disposal of nuclear means, and he wasn't permitted to do so. The court went through a pretty lengthy analysis on the affirmative defenses of necessity and self-defense and some others. And at the end of the day, he was allowed to talk about his subjective beliefs, but his conduct was not privileged. You don't get to just commit a crime because of your subjective beliefs. And the court held that allowing testimony on the environmental impacts would allow a citizen to disrupt the government anytime he felt the government was not properly exercising its choice of values. And that is the case for reference at page 4, and that is at 577. A contrary holding in this case would allow a citizen to disrupt government anytime he felt the government was not properly exercising its choice of values. We cannot permit such things. To allow the state, through his witnesses or through other means, to elicit testimony or evidence relating to his subjective beliefs about the integrity of our election system would produce an absurd result. He's not privileged to do so. If he wants to get on the stand and talk about his own subjective beliefs, I would ask the court to follow the same process that the court did in Olson. Mr. Olson's conviction was upheld.
Of course. I think I probably agreed with the first 30 seconds of the state. The last part, I don't understand how broad they want it. At least as I read Olson, again, only skimming, it's to the necessity defense. We're not raising an affirmative defense. In fact, I don't have a lot of people on I don't have anybody on the witness list that's going to talk about the 2020 election. I just highlighted for the court because I wanted to say, we agree that's not going to be part of the trial. Waite is going to testify that he's interested in election security. That's clear as day. That's going to come out through all the videos and everything else. Part of that's going to be about Robin Voss's statements in 2020 at a group that he's at, and it's been posted over and over again, where he says, look, my vote is secure, you can't go and get anybody's ballot. That clearly is what prompted Waite to do this. That's relevant, Your Honor, at least according to their beginning of the statement. That would be what Waite would testify to. That goes to his state of mind, to his purpose. We're not going beyond that. So in some ways, it's like, I agree with the states completely. We're not bringing a necessity defense. Like, that would be insane for me to go and ask for that, a jury instruction. I'm just forecasting that Mr. Waite has that right to testify to it. It's probably no more than 30 seconds of testimony, maybe a minute. And that's why I said I agree in most parts of the motion to eliminate. We're not going to retry the 2020 election. But the court knows, at least they believe, they acknowledge at the beginning, he's allowed to testify to that. Like, what is his purpose in doing this? I'm going to test that claim. That claim was raised by Robin Voss after the 2020 election. That becomes relevant. Whether or not, we don't have to say the word Trump, we don't have to say the word Biden, we don't have to do any of that. So I'm just highlighting for the court, it's a very modest request of what we have, and otherwise the jury would be without the entire picture of what goes into his purpose, which should be, it is always relevant, especially here where motive goes to it.
I'm not with you on the relevancy part of this. So I think I'm with you on like a 90403 type of argument. I think you probably carry the day in that type of analysis if this is limited testimony, but normally someone's reason for violating the law isn't relevant at trial. It certainly is relevant at the time of a sentencing hearing, their reasoning behind why they did what they did or what caused them to do what they decided to do. But absent an affirmative defense, generally why someone violated the law wouldn't be something that would come into a trial. So that's really what this is. He's saying, I have reasons for what I'm doing, Go ahead.
No, I don't want you to finish. You're the most important person here, so I want to hear tease this out.
Right. Well, I think that's it. Like I said, normally if he wants to come in and say this needed to be done, there were really good reasons behind why I did this, and there were some collateral things that happened prior to me doing it that, in my mind, caused me to need to do this for whatever X, Y, and Z reasons. I don't know why that'd be relevant to determine whether he did the criminal act in the first place.
It doesn't go to the actus reus. I agree with you. Whether or not he typed it in on video, that doesn't go to that, right? It goes to his purpose, right? If his purpose is not criminal, right? Like, his state of mind has to be part of that. He has to do these actions for the purpose of gaining something of value, right? If I'm doing it for a different purpose, and then I'm going to speak to that, then I'm going to do this to alert the public. I'm going to do this to let everybody know this. If I don't do it with the purpose to get something of value or benefit, then he doesn't violate the statute. It's an essential element of it. It's actually in the statute itself. So it goes to his purpose. So long as he's not acting with that illicit purpose, he's not guilty of the crime. And I think that's where I would quibble with the court's example, is that I agree with you on the actus reus, but if his mens rea is not there, which is clearly what we've set out, we haven't, we agree with all the facts. We're disputing whether or not his mens rea was there. And that's where it's relevant. So I don't think it's one of justification. It's one of informing what his thought process was. It's also would be left out of the story as to why he's doing what he's doing, which goes to his purpose.
Yeah, counsel.
Judge, the only thing I wanted to add to that is counsel's conflating motive with intent when he discusses mens rea in this regard. The purpose for doing something is different in terms of motive as it relates to intent. The mens rea in this case would be an intentional crime. That's different from motive. So it just seems like those two concepts are getting conflated when counsel discusses why somebody was doing something. Also, as it relates to counsel's argument that essentially this, as he puts it, gadfly whistleblower purpose, as it relates to his argument concerning thing of value, it's kind of he can't have it both ways, because it seems like he's arguing it's relevant because it shows he wasn't seeking to obtain anything of value, and yet at the same time, if his purpose is to prove this grand whistleblower point, isn't that a thing of value then? Isn't that something that is beneficial? So it seems like he's making the own argument against himself.
Can I respond to that? Sure. I mean, that's going to be part of the jury instructions, but that's exactly what lease doesn't allow. It can't be something of abstract value, right? Lease clearly sets out, this needs to be something tangible. And there's nothing tangible to him gaining reputation or him being vindicated or him furthering his gadfly whistleblower sort of, not persona, but that his pursuits. And so that's the first part. Thing of value has got to be defined. And I'm not trying, it doesn't cut against me in the least. Thing of value has to be something of actual value. Under lease, it's got to be, and that's not something of value. The second part to their argument is the intent and the motive. The intent isn't that it was a careless or reckless or whatever it is. It's an intentional crime. An intentional crime to do something for the purpose of gaining something of value. And if that's what his state of mind is, and I'm doing this so that I can respond and raise the alarm about this, that's not acting for the purpose of gaining something of value.
I don't agree with that, counsel. The act that we're talking about here was him requesting a ballot. That's the act. Once he did that, that's what the state is alleging is the criminal act here, asking for the ballot. So that's the tangible event. That's the tangible thing that he asked for. And my point earlier was that he could have good reasons for asking for the ballot. He could have nefarious reasons for asking for the ballot. But either way, the crime was using someone else's personal identifying information to obtain something, in this case the ballot. And my point earlier was that whether those reasons were good or bad is not relevant to whether he did the crime. So that's the part that I don't think I'm with you on. And that does get into what his motive versus whether he had intent. Those are the difference there ultimately.
So, no, I understand the court's, maybe the tension, if you will. It's that, let's say he goes there and he says, hey, I'm going to do this to demonstrate, right? I'm going to demonstrate exactly what happens, all right? I'm going to use it not for Robin Boss or whatever it might be, right? I'm going to do it on a very limited scale to show you that it can be done. I'm going to do it with my information, right? He's doing that and he's gaining something that doesn't have any value. Right? Like we'd have to concede that it has no value. There is no inherent value to this act.
I would have to concede that what doesn't have value?
That the action of requesting this doesn't have any value. There's nothing attached of value to Mr. Waite for doing this action. Right? There's nothing of benefit or value there.
Well, isn't the right to vote of value or benefit?
I don't know. I don't think the franchise itself can be said that is actually captured within the statute. If that's the state's theory that the right to the franchise, then Mr. Waite is not guilty of that because he didn't interfere with anybody. He goes and returns the ballot right away. He lets everybody know what he's doing. He's not looking to interfere in that regard.
Well, once again, we're getting pretty far afield here a little bit because once the crime has been committed, I don't know that whether he had, once again, I don't know whether he had good or bad reasons for doing that matters. What matters is did he commit the crime or not?
Did he do the actions with the purpose? That's what matters for the crime. The crime isn't just that you did the actions, right? It's not limited to that. It's for the purpose, and that's what has to be read in there. Otherwise, Lisa's guilty. So long as you do the actions, then no matter what your purpose was, and it's not you who's filling that out, then you're guilty of the crime. Well, Lisa says the opposite.
I worry. What I'm going to do at this point is allow maybe a little bit of further briefing on this since this just came up. But I worry that there's no natural stopping point there. For a misrepresentation type of crime, let's ignore this specific fact situation. Whether it be using someone else's name to get out of jail or get a lower bond on a criminal case, whether it be defrauding someone as it relates to their bank account. What you're essentially saying is a defendant would always have a defense to any of those instances because they could come in and say, when I gave my brother's name to the law enforcement officer, I wasn't trying to, get out of getting arrested. I wasn't trying to get a lower cash bond. What I was trying to do is to see if the system worked right. I was trying to see if the law enforcement officer would do his due diligence, if he would check on whether I actually am that person or not, and therefore I'm not guilty. And I don't know that that's the case. I mean, there's case law that says, in like the example I'm showing, that it's done. That's a crime. You don't get to later come in and say, I used my brother's name not because I was trying to get out of anything. I used my brother's name because I was trying to make sure that the system was working properly.
And I think the jury would always be free to reject that, right? He always has the right to raise that defense. The jury is always free to reject that defense.
And I guess what I'm saying is I don't think so, and you're going to have to convince me otherwise, and I'm going to give you an opportunity to do that.
And I want to be sure that I brief exactly what you want. We're talking about the 3 or 4 questions I'm nominally asking about for the 2020 election about the why.
Well, we went into the jury instruction question here, obviously. You've basically conceded the point as far as the legality of the 2020 election, which was the motion to eliminate.
Yeah, that's it.
But then we got into the jury instruction question, so which we still need to have that discussion. But I'm more concerned about element 3, which is what you're arguing in your, ultimately your briefing related to that. Because you want the focal point to be on that, because I don't want to phrase it this way, but you're sort of stipulating the first 2 elements. And the trial is about the 3rd element.
Absolutely.
Right.
Yes.
And that's why I think this discussion matters.
No, absolutely. I just want to make sure for the purpose of the briefing that you want where I'm going to harness it.
Right. And we'll get there in a second. But let me put a pin in this discussion. But did you want to add?
So we're gonna cut it off there.
Okay, I got 2 things.
Fire away, Red.
Number 1, I think the judge, in my opinion, in what he had just said, was a huge stretch of, well, if I allow this, then, it could be setting a precedent for, well, I just used my brother's give me a break. That's a bunch of BS, in my opinion. Not to mention, like we said, I see in the backstage comments, Is that not for the jury to decide, not the judge? And the judge said to convince me otherwise. No, we don't need to convince you otherwise. That's something that the jury is supposed to decide, first of all. Second of all, he stated something about using somebody else's personal identification information to request a ballot. What in the heck does Eric do? And we filed several complaints around the state of Wisconsin. I don't even remember how many, and this was about a year ago. And of course, Mr. Josh Call didn't want to prosecute any of that. And that's stealing our personal identification
And you and I sat in an interrogation room,
for over an hour.
locked in a room,
Yes.
because we wanted to file a complaint.
Yes. And that kind of information is nowhere near what, let me see, reword that. The information you need to request a ballot on somebody else's behalf is not the kind of information that Eric is stealing from us. Eric is taking our name, our birth date, our social security number, our addresses, our phone numbers, our email addresses. Heck, they probably even take your birth weight and how many kids you have too. But okay, I'm being sarcastic. But what did Josh Call do about that?
Nothing.
It was in the trash.
Nothing, Red. And we have to point out some of these comments because they were rolling in during that clip. And I want to point out, for anybody who's not real familiar with this case, on August 25th of 2021, Robin Voss himself stated, and this is on video, stated that voting machines are not connected to the internet, and that is false.
Oh, that must be a conspiracy theory. And you know what happens to conspiracy theories? They're only a conspiracy until they are proven true, and they've been proven true I don't know how many times, over and over.
Robin Voss also said on video that no one could do what Harry was able to do.
Exactly.
It's on video.
Did. Yes, he did. Yes, he did.
Now, someone else points out, and I'd like to know, and we do have a hand raise, and Catherine, I'll get to you in just a minute, but somebody asked a question in the backstage during opening and closing remarks.
Yep.
Do the attorneys have the leeway to step beyond the boundaries of what this judge is setting for the actual trial? Can some of this be brought up in opening and closing? I don't know the answer to that.
I don't believe they can. Once the judge rules on a certain thing, I don't think that they can bring that part up.
Well, it's up to us to get it out far and wide. Everybody needs to share this story, and please follow Hot Government's Telegram page, because I know they've already put out a lot of really good information, valuable information that needs to be shared, and more is coming. And just go on their Telegram page and share it out.
Exactly. And I know there's some more comments I'd like to say about certain videos, but go ahead.
Okay, Catherine B., go ahead.
So sorry, but I'm tired and brain dead, and I forgot what I was going to say.
Oh, I'm sorry.
I'm so sorry I went on my rant there, Catherine.
No, if I think of it, I'll put my hand up again.
Okay.
Well, in my opinion, when they were talking about intent and motive, the video that was taken while he was doing requesting these ballots, to me, that should show right there what criminal, and this is also ties into the judge trying to stretch it as far as saying, well, this could set a precedent. Well, is this person that's going to use their brother's ID to get out of jail going to video it and prove it to be, oh, gee, they weren't doing their job, so I got away with it? No, a criminal is not going to sit and video what they're doing. A whistleblower, on the other hand, is going to do it to prove what they're doing and show people what they're doing.
And Red, we can't stress.
That's evidence.
We can't stress this enough, that Harry was a whistleblower, and what Harry did, it was documented every step of the way. the ballots were never opened. They were presented to the sheriff, who refused to file
He refused to.
to charge him with any crimes.
Yep.
And in fact took it a step further and said, my boat needs to
Be fixed.
or WEC needs to look at my boat and fix it. So I mean, Harry did everything right by the book, documented everything
Yes.
to be a whistleblower, to expose a problem,
And that's why I go back to saying what I said at the beginning. How do you become a whistleblower and show the fraud or the corruption or whatever if this stuff is happening?
and somebody made the comment today when at the post meal
File a lawsuit.
debriefing that, well, no, they said
Oh, I'm sorry.
they said that whistleblowers were meant for people whistleblowing on their employer, not against the government.
Oh,
We
yeah.
can't, you know,
Yeah, you're right.
You've crossed
you're
the
right.
line when you whistleblow against the government.
Because they don't want you to know.
Jeremy points out, how can proving our system sucks give Harry any value other than being a true patriot? And
Amen.
amen to that one, Jeremy. I couldn't agree more, because Harry is a patriot in the truest sense of the definition.
Definitely. I mean, in my opinion, there's not even a question.
And you know, they early on in that video they talked about the fact that I think it was her that said and her, I mean
The state.
the attorney for the Department of Justice suggested that what Harry did was not irrelevant, or not relevant rather, which is just completely BS.
Yeah,
because
how is it not relevant? And I would like to also point out, this was not obviously brought up today, but I remember last summer, and I've told other people about this, and I've sent the article to several people. There was an article written in Green Bay, the Green Bay Press Gazette, that there was a judge that dismissed a case very, very similar to this case. And at the end of the article, it stated in there, Harry Waite never received the ballots.
and this was the judge.
This
who
is
made
the judge in Green Bay that stated this and it was written in this article. So tell me, if he never received those ballots, why is he being charged? And why in the world would a judge in Brown County say, oh, well, he never did that? Well, that judge just proved that you didn't do anything wrong, in my opinion.
Let's see. I want to read another comment read. Catherine wrote earlier, I thought they weren't supposed to literally try the case during a hearing like this, which is kind of what they are doing. Can Harry use this for the trial? And I don't know the answer to your question, Catherine, but it sure seemed like that to me today. And we've sat through a couple of these types of hearings where they were establishing the ground rules for hearings. We did this with the Shire trial, where
Yep.
they argue back and forth about what could be
can be said
presented
and what
to
couldn't.
the jury. And I'm not sure that this one might have been worse than what we saw in the Shire case
I
in
think
terms
so.
of what the judge was going to allow.
Yeah.
This
And I also will say, Commissioner Mark Thompson, whatever his name is, state on 8/28/2022 emergency WEC meeting. I thought we were here to protect Speaker Voss. Yes, it is on video. I've heard it. I've seen it. And it was about this right here.
Well, Red, I'm sure the audience can tell that our blood pressure was raised, and we do apologize that we were traveling a lot today. We spent some time at the hearing, and we had some more travel time.
Yep, on the way back. And thank you for Borman's Bus Line. And we were on Route 1776 today.
Yes.
So thank you for that, and thank you for driving us there safely, back to and from, I should say. So thank you again for.
And so
driving.
another comment in the backstage. We the people have zero faith in the judicial system, and
Well, you know, we've been. Oh shoot. We've been seeing a lot of these cases, these types of cases, probably for President Trump, but you know, how they're suing him and he can't provide this information, that information. But then when you see it happening firsthand in person like this, it just blows you away even more.
Well, it's
If that
it's
makes
frustrating
sense.
as hell because we sat through the Shara trial, and there was no accountability for the people that killed Grace Shara because of our judicial system. We're looking at a Harry's trial where they have tied the hands of the defense, and really, it's pointing toward him being railroaded. And yet, other cases where we want to see accountability for people like Anthony Fauci and the people who've been screwing us for so many years,
Killing us.
and the Robin Bosses of the world. We want accountability, and we're not seeing it. And they're going after the wrong people. They're going after whistleblowers like Harry Waite.
Yep.
And
we've seen that, other places as well in Wisconsin going after whistleblowers.
and Red, I know some people are listening and they're going, oh my gosh, they're talking about Wisconsin again. But you know what?
This is happening. I mean, this is almost identical to what they did to Tina Peters. So it's not just Wisconsin.
And we are a swing state.
So who's next?
So goes Wisconsin, so goes the nation. And people like Harry Waite are trying to save elections because that's part of what we need to save our republic.
Exactly. He's not trying to just save Wisconsin elections. He's trying to save elections across the U.S., period.
Right. And Harry Waite exposed a terrible flaw with my vote in Wisconsin. And if this judge ties the hands of his defense team to expose it, because that's what we need. That's what we need. We need this before a jury. We need it before the people. Mm-hmm. And let the court of
public opinion
raise some hell.
And now you made me forget what I was gonna say. But this, maybe they need to bring up how our freedoms are being taken away. And this right here, it states in the Constitution that you have the right to defend yourself. And if you're going to tie the hands of the defense of the evidence that they can show, how is that defending yourself? How is that allowed? How is that not unconstitutional?
So Red, we're almost out of time. So,
sorry, I'm extremely
right.
fired up.
If you're listening,
so.
I think YouTube is running now, and we'll get it resolved by tomorrow night. But if you're over on YouTube and you want to be a part of the conversation, or on Rumble, hop into the backstage. We got a lot of people back here, and I'm sure that the rants are going to go on in the backstage because people's blood pressure are up over this. And again, we're just going to remind you the Freedom Flame coming up on March 20th. We'd love to see everybody there in person, but if you can't be there in person, please join us virtually.
And then to carry that Freedom Flame over to Monday the 23rd and 24th in Racine, Wisconsin. 717 Wisconsin Avenue in the, Law Enforcement Justice Center.
And we will bring the candles. So at the end of the day, when the trial ends and before we go out to go out to eat, we'll all light a candle outside the law enforcement center and send a message.
We do. We need to send a message.
And we need to fill the courtroom, folks. So with that, we're gonna shut it off. Come on back and join us.
And we're gonna play a special video or short clip in the backstage only after the show.
We are?
Yes, we are.
You had the clip?
Yeah, well, you do.
Okay, awesome. And one last thing, Red.
Tomorrow night.
Oh, tomorrow night. You know what I'm thinking, Red? I want people to come in and try and convince me that that we live on a sphere, because I'm going to show you some videos of why I believe we live on a flat surface.
Flat Earth.
See you tomorrow night, folks.
Friday, 8 p.m. AJ the Rippin' Rabbit AJ the Rippin' Rabbit live. And Sunday, 10:30, backstage only, 2 or more gathering.
Okay, and we're out. Have
See
a
you
good night,
tomorrow
folks.
night.